Another interesting thing is what you Americans call jury nullification, which is a really weird principle for us. And so, what jury nullification is, and how is it that important in the American legal system?
It is a very interesting and quizzical, concept in the American legal system. Jury nullification means simply when a jury returns a verdict that is contrary or seems to be contrary to the law. And there have been some noteworthy or newsworthy cases in recent history that have evinced jury nullification. So one of the most popular cases in modern American history is the O.J. Simpson murder trial, right? When Mr. Simpson was accused of the murder of his former wife and one of her friends. By observers, right, outside the trial, it seemed that the weight of the prosecution's evidence was such that Mr. Simpson had clearly committed those murders. When someone's DNA evidence is found at the scene of a crime, right, that is strong physical evidence that that leads to the conclusion, right, that a person was guilty, and other evidence in the case. And the jury returned not guilty verdicts in that case, and it is believed that the jury verdicts had less to do with the evidence in the case and whether Mr. Simpson committed the murders of the two victims, and more to do with concerns about the legal system and racism that may exist in our legal system, right? That does likely exist in our legal system. So that's sort of a very popular, right, newsworthy example of when a jury returned a verdict that seemed to be contrary to the law and the evidence. And that's what jury nullification means. It's not something that is a recent development in our legal system, however. And interestingly, jury nullification, the power of the jury and the ability of the jury to render a verdict that is contrary to law, is one of the reasons that juries are so valued in our legal system. Beginning at the time that America was still 13 colonies of Great Britain, jury nullification was used as a means of protesting and not enforcing against the colonists the laws of Great Britain, which the colonists believed were tyrannical, and so it was the ability of those juries, before our country was even a country, to protest the laws, basically. So whether it be a protest of laws, a disagreement of laws, a belief that some other principle, like racial equality or some other principle, requires a result that is contrary to law, whatever that is, that motivates a jury to return a verdict inconsistent with the law, we value those things as much as we value enforcing the law. You know, they're considered inherent parts of the legal system. And they bring to the legal system not just the law that may be made by the legislature or the judges, the courts, but it brings to the legal system a regard or a judgment of the laws by the community. You know, it's a direct participation of the community in deciding what it wants its laws to be. You know, and so it's considered a very necessary and powerful part of the legal system.